Good afternoon. My name is Anthony, and I'll be your conference operator today. At this time, I would like to welcome everyone to the Negotiating Your Contract conference call. All lines have been placed on mute to prevent any background noise. After the speaker's remarks, there will be a question-and-answer session. If you would like to ask a question during that time, simply press star, then the number 1 on your telephone keypad. And if you would like to withdraw that question, press the pound key. Thank you, and Ms. Majette, you may begin your conference.
Okay. Good afternoon, everyone. My name is Professor Gwendolyn Roberts-Majette, and it's a pleasure to be with you this afternoon. I'd like to begin by thanking you for allowing me the opportunity to share this information with you. I'm going to begin by giving you a little bit of my background, and then we'll move into a substantive discussion. I'd like to let you know that I love healthcare law issues because they're interesting, and also because 2 of the people that I love are healthcare providers. My husband is a physician, board certified in family medicine and preventive medicine, and my mother is a nurse. My background, I received my undergraduate degree from Emory University, my law degree from George Washington University, and I have an advanced law degree in global health law from Georgetown University. I spent the bulk of my career working on healthcare issues. I've taught many healthcare-related courses, such as healthcare law, access to care and healthcare financing, health and human rights, and a bioethics class in the medical school. My scholarship focuses on patients' rights, delivery system reform, and healthcare reform, and it's been relied on by government agencies as well as cited in leading health law textbooks. A few years ago, I did leave the academy to go and work on Capitol Hill, and I work with 2 of the committees responsible for drafting healthcare reform. I also do some consulting with various government agencies. So that gives you a little bit of my background, and I wanted to let you know that the first-year course that I teach is contracts, so this is something that I'm intimately familiar with. We're going to proceed. I'm going to make my presentation. There will be questions throughout, so I will expect for you all to participate and respond to these questions. At the end of the presentation, I have an exercise that I want you to do that goes through the ideas and concepts that we've talked about in the presentation. We'll go over that exercise, and then I'll answer any questions that you may have. You will note on the bottom of your screen, you can see a handout. It's called Negotiating Your Contract. That is a handout that you should print out now if you haven't already done so, and use that to take notes as we go forward. So you have time to go ahead and print that out as I give some more preliminary information. Again, it's a handout so that you can take notes throughout the presentation. This presentation has 3 purposes. First, I want you all to start thinking deeply about your potential employment relationship. Second, I want to introduce you to some legal terminology. And third, I want to introduce you to some of the ideas and topics that you might see in a typical employment contract for healthcare professionals. So those are my overall goals. Now, I am a lawyer, so I have to begin this presentation with a caveat. And the caveat is that this presentation is based upon general contract principles. It's not unique to any jurisdiction. Contract law is one of those areas of the law where the states decide what the rules are. That means that each state has their own legal rules that govern contracts. And so for you to understand fully the impact of an employment relationship that you're entering into, you need to consult with someone who is licensed in the jurisdiction where you are going to be practicing. Okay, so what should you do before you sign an employment agreement? 3 basic steps. The first one is extremely important. You need to make sure that you read the document, that you read it very slowly, and that you read it carefully. I know that oftentimes people sign documents, you think about those rental car agreements, or when you buy a consumer good and you don't read the document that you're signing, but the law says when someone signs an agreement, they are bound to it. So you can't later say, I didn't understand. So you have to make sure that you read the document very slowly and very carefully. When you read the document, if it references any other documents, you should ask for a copy of those documents. because by referencing that document, that means that the additional document is part of the contract. So you read the contract and you read any documents referenced by the contract. The second most important thing is that you have it reviewed by a lawyer. And there are two basic criteria. First, the person should be licensed in the jurisdiction where the contract is going to be enforced. And second, you want to get someone who is knowledgeable about healthcare issues. Healthcare law has some very unique rules that are specific to healthcare professionals, and so it's not good enough just to get someone who has done employment contracts. You want someone who is knowledgeable also about the healthcare industry and the rules that govern that industry. The final thing that you need to think about is, when do you need to get back to the employer? What's the deadline? And you want to make sure that you give the attorney enough time to review the contract and help you to make any changes that might be necessary. So I would say I would try to give that person at least a week. If you could give them longer, fine, but I would try to give them at least a week. Now, since I've said that you should hire a lawyer, people will generally ask me two follow-up questions. The first question is, how do you find a lawyer? And there are a couple of recommendations that I have here. First of all, I would ask healthcare professionals that I know, do they have any attorneys that they've used in the past? Second, I would ask my family members and friends if they know any healthcare attorneys. Third, you could contact your local bar association to find out if they have a health law section, and sometimes those health law sections have a directory of the members and their particular areas of practice. And the fourth way that you could find someone is by consulting the American Health Lawyers Association. They have a monthly bulletin that they put out, and in one issue of the year, they list all of the healthcare firms across the United States and their areas of specialty. So those are 4 different ways that you could find potential attorneys. You want to get at least 3 names. This is a high purchase item, so just like when you purchase your TV and other high purchase items or computers, you want a comparison shop. I would get at least 3 names, and then I would call at least 3 attorneys. I would ask them a couple of questions. 1, what is their experience working with healthcare professionals? Have they had experience reviewing contracts for healthcare professionals? I would ask them what process they use. How do they work with that healthcare professional to help them understand the agreement and to negotiate for the agreement? And then finally, I would ask them their fees. How do they calculate the fees? In the older days, attorneys primarily charged by the hour. And this is still the predominant rate, but it's changing. So they might do a per diem or per assignment type of arrangement. So you ask them what that is, and then that can be the basis for you to compare the names that you have. The next question that I often get after that is, well, how much will it cost? Now, I can't give you an exact amount of how much it will cost, but what I can do is give you some of the factors that impact cost. So one factor is geographic location. As you can imagine, just like other goods in New York or California are more expensive than areas like the Midwest, Chicago, or the South, it's the same thing with lawyer fees. Another factor that impacts fees is the size of the firm. Is it a large firm, 100 attorneys or more? Is it a medium-sized firm, 50 attorneys, around that amount? Or is it a small firm, 20 or 10 attorneys or less? As you can imagine, the overhead associated with the size of the organization impacts the fees that they have to charge. 2 other factors that may impact fees include the experience of the attorney. As you can imagine, more experienced attorneys cost more than lesser experienced attorneys. And then the final factor is the complexity of the legal agreement. If it is a simple 5-page document with standard terms, that's not going to take the attorney as much time to review and give you feedback as opposed to a substantial contract of 20 pages or more with a lot of different and varying terms. So those are some of the factors that impact fees. But as I said, this is very important. the person who is giving you that agreement most likely has had that agreement reviewed by an attorney, fully understands their rights and obligations, and you should invest in yourself and hire someone to help you so that you fully understand your rights. Okay, so I said that we were going to have some questions throughout. Here's the very first question that I would like for everyone to respond to. What is a contract? Oh, okay. We only have a couple of responses. We want to see a couple more responses. Okay. These are all very good responses, especially the one that says it's a legal agreement between parties. So two different definitions of a contract. I think that the key way to think about it, since we're talking about employment contracts, is that it's a document that is going to govern the employment relationship between the employee and the employer. What I teach my law students is that a contract is an agreement that contains promises that the law will enforce. So not all of the promises that we make are legally enforceable, i.e., if I promise to take someone to dinner, that's not a legally enforceable obligation. So the fact that people are putting in their responses that it's a legal agreement that the law would enforce is very, very important. Now, contracts have several purposes, three of which I've noted and put on this slide. It memorializes the rights and obligations. It establishes the rules that will govern the relationship, and it will serve as evidence of the intent of the party. So if parties are thinking that they have certain obligations but they're not sure, they can go and look at this written document, if you have a written document, to find out what the party's intent is. And if the parties have a dispute and they cannot resolve it and they have to file a lawsuit, the court, when trying to figure out what the contract means, will look at that written document to the extent that a written document exists. So contracts can really help the parties avoid misunderstandings and improve their communication. Now what I want to do is give you the legal requirements for creation of a contract. There are 5 basic requirements, but I want you to focus in on the 2 that are on this slide. I'm going to tell you all 5, but again, as a layperson, the ones that you really want to pay attention to are the one that's on this slide. So the first thing that you need to have a valid contract is to have an offer. And an offer is basically a proposal to enter into an agreement. If the party receiving that agreement likes it, does not want to change anything, agrees to the exact same terms, then they have provided acceptance. So you need an offer plus acceptance to have a contract. The third requirement is that you have consideration. Consideration is a legal term of art. You will oftentimes see this phrase, consideration, in contracts, all types of contracts. It's not unique to employment relationships. And what this idea of consideration means is that you have an exchange. I talked about earlier that a contract contains promises. So what each side is doing is exchanging promises. You have to have a quid pro quo or an exchange. The fourth requirement is that the parties entering into the agreement have the legal capacity to do so. That means the law recognizes the ability of these individuals to enter into a contract. So now I have my second question. And the second question is this. What types of individuals should the law protect and prohibit from entering into contracts? What type of individuals should the law protect and prohibit from entering into contracts? All right. Any other answers? All right. So very good. You've put the key groups in there. Minors are individuals that the law protects because we don't think that they fully understand the nature and obligations of their rights, as well as people with mental impairments. So people who are determined to be mentally incompetent, there is a medical aspect to that, but then there's also a legal aspect to that. So we want people to enter into agreements who understand the nature of the obligation that they're into. And so if these individuals, minors or people with mental impairment, sign an agreement, then that would be a basis for those agreements to be nullified. Okay, so we talked about the requirements. I said you have to have an offer, you have to have acceptance, you have to have consideration, you have to have capacity, and then the final requirement is that you have to have a legal purpose. The reason that the parties are entering into the agreement, it needs to be legal. So if parties enter into an agreement, let's say to rob a bank, that contract would not be enforceable because we don't have legal purpose. Okay, so during the process of negotiations, the parties go back and forth, and you're trying to figure out what's the goals of each side, and you want to come up with an agreement that meets the needs of each side. So in this process, if someone receives an offer and they don't like the terms, they want to change a term, even if it's just one term, then what they're doing is they're rejecting the offer, and they can make a counteroffer that has the new term that they like. And so a counteroffer is a modified offer. So you receive an offer, but you don't like it, you want to change something, that is legally called a counteroffer. So the parties go back and forth until you have what I talked about before, offer and acceptance. Basically meaning the parties now have agreed fully to all the same terms. Another thing that I wanted to talk about with respect to the negotiations is to kind of help you to start thinking about, well, what's your negotiation power? When you're negotiating with a large employer, generally you will have less flexibility in the other side's willingness to change the terms. And the reason for that is that large organizations like to have consistency, and so they might be hesitant about changing terms. That does not mean that you should not ask what the term means, clarify it, maybe try to fine-tune it, see how it has applied in the past to other healthcare professionals, but I just want you to understand that. That does not mean that you should not try, but it just helps you to think about, as you're thinking about the overall negotiation, what should be your approach, and then if you get a rejection, they don't agree, that you won't be shocked and that you will have a plan B. So that means smaller organizations generally have more flexibility. The final point that I wanted to note with respect to negotiations is if you have a bitter, contentious negotiation process, when ideally people are on their best behavior, that can foreshadow what the relationship might look like in the past. So that's just something to think about. Okay, so now we understand what the requirements for creating a contract are. I want to let you know that you have two distinct contracts that you are going to be working with. You have one contract with the National Health Service Corps that set forth the requirements for the government to loan you money to go to school. If you haven't read that contract, I would strongly suggest that you go back and read it. So that's one contract. And then you have a second, separate and distinct contract with your employer. Now these two contracts are related, and some of the terms of your National Health Service Corps contract will impact the contract with your employer. These two documents should be consistent. But again, the key thing that I want you to see is that you have two separate contracts that have separate and distinct obligations with them. Okay, so now let's start talking about the agreement itself. Generally, contracts will have a title identifying the type of contract that it is. And so what we're talking about is an employment relationship. And the other thing that you will see is at the beginning of the document, it will identify who the parties are to the agreement. And at the very end of the document, you will see a signature page where the parties who are entering into the agreement sign and date. Sometimes at the signature sections, you will also see an authority to execute clause. And basically that authority to execute clause says that the person who is signing on behalf of a corporate entity has the power to bind that corporate entity. So I just wanted to give you the heads up about that. The other thing that I wanted to let you know is that contracts can be oral or in writing. I don't suggest that people have just oral contracts, but you can do it. But sometimes the law requires that contracts be in writing. So one doctrine called the statute of frauds, one of those rules is that if a contract cannot be performed within a year, i.e. a multi-year contract, it must be in writing. So you all will primarily be signing multi-year contracts, and they should be in writing. Okay, so you have this document, the parties identify themselves, and then they sign it, and that signing means that you're agreeing to be bound by this document. The very first part of the contract is likely going to deal with professional qualifications. And here what we're looking for is what's required to obtain the job and then what's required to maintain the job. Those requirements are going to be unique to the type of healthcare professional that you are. And so the industry standards are going to govern what will likely be included here. What you see on this slide is targeted a little bit more to physicians. Everyone who is part of a profession that has licensure, that's going to be a requirement. Board certification is something that physicians generally are required to do more and more by potential employers. Do you have a valid DEA number? And do you have hospital privileges if that is something required? Again, what's going to be in this part of the section is going to differ depending upon the type of healthcare professional that you are and what are the industry norms. The next part that you will see in an employment contract is going to be a duty section where the agreement sets forth what the employee is required to do. I want to give you two perspectives here. So from the employee perspective, generally what the employee wants is to have very specified rules so that they will know exactly what it is that they are going to be doing. But the employer perspective is a little bit different. Of course, they want somebody who is competent and qualified. That's why you had the professional qualification section. But they also want to have the flexibility to be able to move people around to meet the company needs. So I just want you, again, to understand that from looking at rules and seeing how the contract might likely be drafted. When we think about duties, there are four areas kind of that you need to think about. What's the scope of the duties? What are your hours? Are there any performance or productivity standards that are set forth? And what about site locations? As you know, as National Health Service Corps scholars, you have to work at a HPSA, Health Professional Shortage Area site. So you want to make sure that you are only working at a HPSA site. That is very, very important. Now going back to duties and thinking about this and fleshing this out a little bit more. What are the office hour requirements, and do you have any call rotation? Again, the nature of the duties is going to depend on the type of healthcare professional that you are. So when we think about office hours, one thing that we want to think about is, does the National Health Service Corps have any standards to define office hours? If they do, then your employment contract needs to be consistent with those National Health Service Corps requirements. Does the National Health Service Corps define full-time work? What does that mean? It should be consistent, your employment contract, with the National Health Service Corps. One thing that you do have to be cautious about is that you don't take on too many administrative responsibilities that will impede you from meeting the requirements of the National Health Service Corps. If you're the type of professional where call is part of what you're required to do, then there are 3 things that you should be thinking about: frequency of the call, form of the call, and compensation. By frequency, I mean how often will you be on call? Will it be 1 in 3, 1 in 5, 1 in 7? That should be specified. What's the form of the call? Is it simply that you have to be in-person call, or is it telephone call, or is it a combination of both? Again, industry norms will impact that, and what the needs of your employer will impact that. But that's something that you want to clarify so that everybody's on the same page about the form that the call is going to take. When we think about compensation, here, what happens if you were supposed to be on call 1 in 5, but you have actually been on call 1 in 3? You want to, at the beginning of the relationship where you're setting out what the call schedule should be, that you also talk about what happens if you're on call more. It's very common that it happens, and so you should talk about beforehand what's going to be the consequence. So you could be compensated by having less call in the future. The document can specify that. You could be compensated by getting extra pay for that. The document should specify that. Or maybe it'll be a combination. But the key thing is to think about in advance, because having to be on call at some point more frequent than what was agreed to is something that comes up frequently. So that's something that you should pay attention to. Additional duties that might be specified in the agreement have to do with patient care records. Of course, as healthcare professionals, you should make sure that your entries are timely, accurate, clear, and if you're still using paper records, legible. From an attorney who has represented hospitals and physicians in the past from the defense perspective, if you don't have something in the record, that means that you didn't do it. And so that can not only lead to lawsuits for malpractice, but also it could lead to fraud and abuse charges, and you don't want that. So make sure, again, that you're putting them in there in a timely manner, that it's accurate, that it's clear, and that it's legible. Do you have any administrative patient management responsibilities? What about administrative responsibilities? That should be specified and talked about. And then at the end, you will oftentimes see what I call a catch-all clause. And that catch-all clause basically says that you will comply with all of the policies and procedures of the employer. 3 more duties to think about: quality assurance and cost control. Of course, you may know as healthcare professionals, there's been a big push to improve quality, especially with the Institute of Medicine report coming out talking about crossing the quality chasm, and then a later report talking about to err is human. We need to put mechanisms in place to make sure that we improve the quality of care. So as a healthcare professional, you might be called upon to make sure that this happens. And payment rules, like from the Medicare program, which is the federal program that provides financing for healthcare to seniors, and other private insurers, they have rules and provisions in their contracts that talk about improving quality. From a cost side, you also might have to participate in activities to help to control costs. As again, in the United States, we have one of the highest underlying costs across the world. And so it's a major effort to try to get us to be able to control healthcare costs in the United States. And as a healthcare professional, you will be called upon to participate in those types of activities. Teaching. Some of you might have teaching responsibilities. If that is something that is expected, or if that's something that you would desire to do, then that's something that should be talked about. Another point that I want to put in here is moonlighting. Generally, this is something that professionals early in their career like to participate in, and so I wanted to talk to you about this. So if you see a clause in the agreement that attempts to limit your ability to moonlight, I don't want you to be surprised. The reason that that clause is in there is because employers are hiring you to provide professional services, and they want to make sure that you're not doing anything that will impede your ability to provide competent, quality services. So that's why you will see sometimes moonlighting clauses. They're not always in there, but if it is in there, I don't want you to be shocked. Sometimes the employers, when you're trying to negotiate with them, they won't take it out exclusively. So if they don't, the key thing that you want to make sure is that if they're requiring prior approval for the moonlighting, that they not unreasonably withhold their consent. So that's the key thing. They should be reasonable in the consent if that is something that they put in the agreement. The second thing that I want you to be aware of as it relates to moonlighting is that you need your own separate malpractice insurance. I'm going to talk about malpractice more fully in a couple of more slides, but the key point is that if you are engaging in moonlighting, you have to have your own separate policy. The employer's malpractice policy covers your activities when you're acting on behalf of them, not other organizations. Other terms that you have to think about, of course, are financial compensation and benefits. 3 areas to think about: salary, overtime, and bonuses. Salary, overtime, and bonuses. Now, when we think about salary, oftentimes people just focus on the amount. You need to be thinking more than about the amount. The amount is important, but you also want to know frequency, meaning how often will you be paid? That should be specified. Is it going to be monthly, biweekly? How often? Now, I have a real-life example as to why this term is important. I had a physician friend one time who was working for an employer, and that employer started to have financial challenges. And the employer was not paying this individual on time, and at the time they contacted me, they had not been paid. So I asked them to send me the contract. I'll look at it, see what I could do. And when I got the contract, I said that they should be paid biweekly. So I wrote a letter, and I basically explained the facts, and I said that the employer was in breach, meaning they had violated a provision of the contract, and if the employee was not paid by a certain amount of time, then we would proceed with further legal action. So it's important that that be in there. The other thing that's important when you have a multi-year contract is that there be something in there that talks about increases, because I'm sure you don't want to be paid the exact same amount for every year. So that's also something to think about. With respect to overtime, how is that defined? What will be the compensation? Again, these things will be fleshed out based upon industry norms, based upon the type of professional that you are. The final area that you should think about is bonuses. The employment agreement will set out financial objectives and performance criteria for you to reach whatever bonus the employer comes up with. The thing with bonuses is you don't look at it and get happy and excited simply because it's there. You have to start thinking about, given the terms, can I achieve it? It means nothing to you if it's not achievable. So I do have another real-life example, and this one involves my husband. So when my husband finished his residency program, he was approached by a hospital that wanted to set him up in practice, and they would fund it. He would initially be a salaried employee, and then over time, he would take over and become the owner. And so the first year he was on salary, we were satisfied with the salary. The second year, the salary was not what we wanted, but it had a bonus. And we would have been satisfied with the contract if you combine the salary and the bonus. The problem is when we started to think about the bonus more, it was not obtainable. The bonus was dependent upon him growing the practice by a certain number of patients. The problem was that the hospital controlled the marketing budget, and they weren't really willing to invest there. And the second problem was that the hospital really did not know how to market for a physician practice. They were really used to marketing for a hospital practice. So when we thought about it, the bonus was not obtainable. So that's something that you want to think about when you see bonuses. Not simply that it's there, but is it something realistically that you can achieve? Then it will have value to you. Okay, a couple of more terms to think about as it relates to financial compensation and benefits. Severance pay. Severance pay is not something that you're going to see in a typical agreement unless you're a high-level individual. So if you're a high-level position that you're looking at, then they will set forth a severance in the beginning, or if you're taking on like a risky position. But most of the time, severance is negotiated at the end when the parties are terminating their relationship. Paid time off. This should be included in the agreement. So we want to know how much time off are you going to get for continuing education? How much time will you get off for vacation? How much time off will you have for sick time? That should be specified in the agreement. Insurance and retirement, again, that should be specified in the agreement. Now, I do want to note, generally it will be a general clause that says that you will be entitled to health insurance, life insurance, and retirement, depending upon what it is that they're offering. But they're not going to put in there the specific carriers. They're not going to put in there that you will have health insurance under Blue Cross Blue Shield. And the reason that they're not specific like that is because the employer does not want to have to change all of their employment agreements every time they change carriers. So the key point is a general provision outlining that you will be entitled to specific types of insurance and retirement. Association and journal dues and fees. Good employers will pay something towards association and journal fees. And the reason I say that good employers would do that is because good employers recognize that they need to make sure that their employees have the latest skills and abilities to continue to remain competitive in their market. And so there should be some investment there. If you happen to work with an employer who is either doesn't provide any money or does so in a very limited fashion, that doesn't mean that you shouldn't invest in yourself. Remember, you are the professional. It's your skills that should be maintained, and if you want to be viable and competitive in the employment market, should you want to leave, then that means you need to invest in yourself. Another term that you will often see is equipment. So depending upon the type of job that you're in, what type of equipment is needed to perform that? I'm thinking more specifically about beepers or cell phones. In this way, some employers will provide those pieces of equipment to you, but sometimes what the employers will do is they will provide you an allowance to help you to pay those costs. At the end of the day, the key thing that you want to make sure that you do is that you understand what are the industry norms as it relates to financial compensation and benefits. And so you want to check with your professional associations and see, do they put out salary surveys. For example, the American Academy of Family Physicians, they used to put out a salary survey that was based upon salaries in regions. So it wasn't just one, abstract average, but it was regionally based. And so that's something that you should make sure you should do. I would also talk to other healthcare professionals to find out what type of salaries and benefits they're being offered so that you can negotiate appropriately. Okay, so let's talk about malpractice. Your malpractice coverage will come in one of two ways. Either your employer will purchase a malpractice policy from an insurance carrier, or your employer will receive protection through the Federal Tort Claims Act legislation. The Federal Tort Claims Act legislation generally does protect federally qualified health centers. But the employer that you're working with, they know whether their coverage is under this legislation, and they will tell you that. The type of coverage you get is the broadest type of coverage. It's equivalent to occurrence-based coverage. So the key thing that you just need to know is if you are covered by that, then you're fine. And when they bring you on board, they'll educate you about the process and how everything works. If you're not covered by the Federal Tort Claims Act, which will be, some people, then your employer will purchase coverage from a private carrier. There are three basic types of insurance coverage. The broadest type and the most extensive is what is called occurrence coverage. And so the reason that occurrence is so expensive is because the insurance company has to carry a risk for a long time. So occurrence coverage, the only thing that has to happen for that to be trigger is that the incident leading to the lawsuit occurs during the policy. That's the only thing. So if somebody files a claim 10 years later, then the occurrence policy picks it up. And that you can see if an insurance carrier is carrying that risk of exposure for a long time, they're going to charge more money. And because occurrence policies were so expensive, the industry created two other types of policies. The second type of policy is a claims-made policy. And here, the insurance carrier's risk is narrow, so that's why they're able to price these types of policies cheaper. So for a claims-made policy, two things need to happen during the term of the policy. The incident leading to the litigation has to occur during the time. So let's say, for example, the policy ran from January 1st to December 31st, 2012. The incident would have to be filed during that time period. The incident would need to occur during that time period. And the claim, that means the litigation lawsuit would need to be filed during that time too. So if the claim itself is not filed until 10 years later, that wouldn't be picked up by the claims-made policy. You have to have a second policy called the tail. So the tail supplements the claims-made policy to pick up those claims that occurred during the claims made but are filed years after the terms of the tail. So a claims-made policy plus a tail is equivalent to occurrence. So your employer might buy claims-made policy, and that could be done at the beginning of the relationship. The tail, that policy is generally purchased at the end of the employment relationship, and the cost for that is sometimes entirely borne by the employer, sometimes the employee picks it up, sometimes they share. But to get more information about the cost and fully understand the types of malpractice coverage, you would need to talk to a malpractice insurance carrier. The key thing I want you to get from this is just to understand the terminology of what occurrence is, what a claims made is, and what a tail is. Another part of an employment agreement will have to do with billing. There will generally be a provision in the agreement assigning your right to payment to the employer. As the individual providing services, you're the one that should receive the payment legally. But as an employee, you assign that right to payment to your employer. And so that is something that is typical in the agreement. That's not something that you negotiate around. In fact, there are other contracts that dictate that this necessarily be in your employment agreement. For instance, when employers negotiate with the insurance companies that they're participating providers, they want to see that there is an assignment right in those agreements. So that's not something that you negotiate around. I just want you to know that it will be there. The key thing that you need to know with respect to charges is that the employer will be billing on your behalf, and you just want to make sure that it's being done lawfully and orderly, and that you receive reports about the billing done on your behalf. And the reason that you want us to receive these reports is because you want to make sure that the billing that's being done is consistent with your understanding of the services that you actually provide. If the employer is engaging in fraudulent conduct or not doing that appropriately, they, of course, will be liable for that when they're found out. But you also could be liable. So when you receive those reports, you just want to make sure that you look at them just to make sure that it's consistent with your understanding of what type of services you've been providing. The term of the agreement. So the contract will set forth how long this agreement will last. If it's a 3-year agreement, a 2-year agreement, how long. And if you have a multi-year contract, then you will have an initial term period, probably 1 year, and then the agreement will automatically renew for successive terms unless someone gives notice. So that's generally how a multi-year contract might work. An initial period with automatically renewal, and then the renewal period is generally equivalent to that initial period. So it would renew again for a year, and again it will renew for a year. So that's just something that you should understand. Performance evaluations. You do want to know how well you're doing and whether you need to improve. And so performance evaluations will lay the groundwork for you to be entitled to a raise. So having something in there about performance evaluations at least once a year is good. The other thing is that you want to have something in there talking about salary review or increases. Increases, especially if it's a multi-year agreement. I have seen contracts where it specifies in year 1 the salary will be this, in year 2 the salary will be this, in year 3 the salary will be this. So, but not all contracts do specify it like that. If they don't specify a specific amount, at a minimum what you want to do is have a provision requiring that your salary will be reviewed, and that gives you the opportunity to negotiate and talk about what your raise should be. So in the last slide, we talked about the fact that the parties will agree in advance how long the agreement should last, what would be the term. But sometimes the agreement will terminate before the term the parties have specified. So some of the reasons include that the healthcare professional dies, the healthcare professional becomes permanently disabled and is unable to perform their job. So it's not simply that they're permanently disabled, but that they are no longer able to perform their job. It's a combination. Sometimes you will see in the agreement a without cause clause. Without cause clauses are not bad. That just means that the parties can end the relationship by simply providing notice that they want to terminate. You don't have to say why. You just have to provide the notice within the time frame set forth in the agreement. Without cause clauses, they're not bad if they apply to both sides. That means it should apply to the employer and it should apply to the employee, and the requirements should be the same. They shouldn't be different. And the time frame, it can vary. This provision says 90 days. It could be 60. The key thing that's driving that is employers are trying to think about how much time they need to train someone else and replace the individual that's leaving. So that's what's going to drive that number. With cause clause, that's bad. But contracts do have in there with cause clauses. And when I say bad, I actually mean that something bad has happened that requires the parties to terminate under this provision. So earlier we talked about the fact that when you get a job under professional qualifications, there's going to be a standard about what's required to obtain the job, but then the other key part is what's required to maintain the job. If you lose what's required to maintain the job, then that's going to be a basis to terminate with cause. So if you're required to have a license and you lose it, that's a basis for the employer to terminate with cause. If you lose your DEA number, if you lose your board certification, if you lose your hospital staff privileges, those are bases for the employer to terminate with cause. Of course, if you're providing care that's jeopardizing the health and safety of patients, that's a basis to terminate. If you're actually convicted of a crime, that's a basis to terminate. If you're illegally possessing narcotics or using them, that's a basis to terminate. And sometimes I've seen catch-all clauses. These are generally in more complex agreements that say if the individual is engaging in unprofessional, unethical, immoral, or fraudulent conduct, that's a basis to terminate. From the employee side, there are some reasons that you could terminate for cause, i.e. the employer that you're working with, they're sanctioned by the government. So some government agency, the Office of Inspector General, the FBI comes in and they are alleging that your employer is engaging in fraudulent activities under investigation. That can be a basis for you to terminate. If your employer is undergoing bankruptcy, that can be a basis to terminate for cause, and if a party breaches the agreement. So let's talk about also what impact termination with or without cause might have on your National Health Service Corps contract. Again, we said it's a separate and distinct contract, and it has obligations that you're required to meet. So if you don't fulfill your National Health Service Corps obligation, that can be a basis that leads to breach of your National Health Service Corps contract. If you don't meet their clinical practice minimums that are set forth by the National Health Service Corps, that can be a breach. If you lose your license or have a restriction based on your license, that can be a basis for breach. The consequences for breaching your National Health Service Corps contract are significant. Again, a reason that you should go and read that contract. And so what you want to do is you want to make sure before you make any significant changes, or if any of these things happen, that you talk to the National Health Service Corps and work those things out so that you can avoid the significant monetary penalties. Another term that you might see in your employment agreement, more likely for physicians, would be a restrictive covenant. And physicians sometimes, I would say, overreact or get into a tizzy about restrictive covenants. And I want you to understand why they exist. Restrictive covenants is not unique to the healthcare industry. It's basically designed to protect the legitimate business interests of an employer. And what it's designed to do is to make sure that the employee does not engage in any inappropriate activities. What you should do is think about, if you had a business, if you had a practice, if you had a hospital, what type of employee conduct would you think would be appropriate for your ex-employee to engage in? That's what you have to think about with respect to restrictive covenants. That doesn't mean that you don't negotiate around them, but I just do want you to understand the other side of the equation. So restrictive covenants, they will be enforceable if they're reasonable. Some jurisdictions, a very few, less than a dozen, by statute absolutely prohibit restrictive covenants as it relates to healthcare professionals, primarily physicians. So again, that's why it's important that you hire someone who is knowledgeable about the laws in your jurisdiction so that you understand whether this term should or should not be in your agreement. If a statute doesn't prohibit it, then what the court is going to do is they're going to evaluate the term to see if it's reasonable. And they're going to be looking at three specific areas. Is it reasonable in scope? I.e., what is it prohibiting you from doing? Is it prohibiting you from actively soliciting former patients? That's permissible. Then it will look at time. How long are you restricted from engaging in this conduct? Today, anything more than 2 years should be a red flag for you. A long time ago, when our society was not as mobile as it is now, you could have restricted covenants for longer periods of time. But today, anything over 2 years, I think is suspicious, and I would check into that. The geographic area. What is the area in which you're prohibited from acting? Here, it should be the area where the employer is pulling their patients. And the employers know this. They know where their patients are coming from. So, for example, if you had a site or an employer that had multiple sites, you only worked at site A, it would be unreasonable for them to have a restrictive covenant that covers all their sites, like site B. You should be able to go and work in that area because you are a threat to them. You didn't have any established relationships that were built upon their previous employer. So when looking at geographic area, reasonable should generally be where the employer is pulling their patients. Sometimes, even if the agreement is reasonable as a whole, the court will decide not to enforce it. They might look at the impact of the restrictive covenant on patients and decide that they don't want to enforce it. Another point to note is sometimes these agreements, they might be they might be drafted too broadly, and if you didn't get advice or you weren't able to negotiate down the term, then courts might decide that they will modify it. Not all courts do that because we don't want to encourage employers to be drafting agreements that they know are unenforceable, but people don't challenge it. So that, again, is state-specific. Some states, it's like if any one of these things, scope, time, or geographic area is unreasonable, that's a basis to strike the clause, and it wouldn't apply. Oh, and the final point that I want to say with respect to restrictive covenants as a healthcare professional is this. What you have to do when you retrieve your agreement, if it has a restrictive covenant in there, is to think about your long-term goals. What do you want to do? Is this an area that you think that you might want to remain in and you want to preserve that opportunity, or you're sure that you want to remain in this area? Then you want to think carefully about the impact of this restrictive covenant and negotiate. But if you don't have any intention of staying in the area, you want to not put as much energy into negotiating over that. Remember, you're negotiating an entire agreement, not specific parts, and so you have to have an overall strategy to go about that. So it doesn't make sense to expend energy fighting over something if it's not really going to impact you. Medical records and proprietary information. As you know, well, I mean, you might not know this part. You know that medical records and the information contained within them should be confidential. So that is governed by state law and the federal law HIPAA, which mimics the purposes for which individuals can use information in medical records. The other thing that you should know is that medical records are legally the property of the employer. You should not take them. You should not harm them in any way. And so when you leave, basically all you can take with you is your personal belongings. You also might have been exposed to proprietary or confidential information during the time period that you work with the employer. And you're required to keep that information confidential and not disclose it. Now I want to talk about breach. So the legal term of art, breach, means that someone has violated a provision of the contract. If that occurs, there are three options. You can cure, that's a legal term of art, or fix the breach. The parties can resolve the dispute using alternative dispute resolution, or the parties can use judicial mechanisms, which you're probably more familiar with. So sometimes contracts will have a curing provision. And basically what this will do is say if a party is in breach, the other side will give notice, and the non-breaching side, and the breaching side has to fix their breach within a certain amount of time. So the contract doesn't automatically terminate upon the breach happening, but you allow the parties to work it out, give them some time to fix it. And if the side that is in breach fixes or cures their breach, then the employment relationship will continue under the terms of the contract. If the breaching party does not fix the breach, then the agreement will terminate at the end of the time period given for them to fix it. The second means to handle a breach is through alternative dispute resolution. The primary mechanisms are mediation and arbitration, and these alternative dispute resolution mechanisms were created to be a faster and maybe cheaper way to handle disputes between the parties. With mediation, what happens is a third party is brought in to work with the parties and try to help them resolve it. Arbitration is different. Arbitration is more like a court proceeding in the sense that you have a third party or a panel of judges that will decide the rights and obligations of the party. A benefit of arbitration is that you can get decision makers who are knowledgeable about the rights and norms of your particular industry. So for example, the American Health Lawyers Association, they have an arm that trains healthcare lawyers to be arbitrators. And healthcare lawyers, they understand the legal rules and they're very knowledgeable about the healthcare industry. So that can be a benefit. With judges, the judges know the law, but they don't necessarily know what are the norms that govern that industry. A downside of alternative dispute resolution is that, especially for arbitration, you're paying the decision maker. You're paying that arbitrator or panel of arbitrators to hear your case. So that can be a downside of arbitration. Both mechanisms, judicial mechanisms and arbitration, have like filing fees. So that's just something to think about. The final mechanism to resolve a dispute between the parties is by filing a lawsuit. If you file a lawsuit, there's two types of remedies that you might seek. The first type is an equitable remedy, and that includes an injunction or a specific performance. An injunction is an order by the court to stop doing something, an order by the court to stop doing something. So an example, we talk about restrictive covenants. If there was a restrictive covenant in your agreement and it said you could not practice within a 5-mile radius and you decide to set up practice within a 2-mile radius, then the employer would file a lawsuit with the court and they would seek an injunction from the court to get you to stop practicing in that area. The opposite of an injunction is specific performance. Specific performance is an order by the court to do something. So injunction and specific performance are two types of equitable remedies. More likely than not, if there's a breach, you will receive damages. That means money. And two types of damages. One is compensatory damages, a legal term of art. It basically means your out-of-pocket cost. The other type of damage is what is called liquidated damages. Sometimes in the contract, you will see what's called a liquidated damage clause. And basically what happens here is at the time the parties are negotiating the initial agreement, they sit down and think about what's the impact of a party breaching the agreement. And they come up with a dollar value that reflects that harm. So if you have a liquidated damages clause provision in the agreement, then the parties only have to litigate one issue: who has breached the contract. If you don't have a liquidated damage clause in the agreement, then you have to litigate two issues: who breached, and second, what are the damages the party should be entitled to. Now what I want to talk about is some general contract governance provisions. One clause that I want to point out is called an entire agreement clause. All contracts do not have these provisions in there, but I think that these are some of the more important ones that you might see. So we talked about the fact earlier that when you're in negotiations, the parties are going back and forth. They are making offers and counter offers, and they are putting forth terms that they would like. What the entire agreement clause says is the final executed agreement of the parties is the document that controls the parties' rights. So if there was some term that you talked about before that did not make it into the final agreement, you have lost that benefit. So if that agreement is in there, then it makes it difficult for you to negotiate and try to get an excluded term in the agreement. Sometimes parties need to change the agreement as they're going forth, and so they want to modify the agreement. I suggest that modifications be in writing. Now, one side cannot dictate a modified term. Both sides have to agree to the change. So someone can propose it, but the other side is not required necessarily to accept it. And I think, again, that is the better practice to do things in writing as opposed to doing things in oral, because people can forget. Sometimes they really forget, and sometimes it's convenient. But so I think that writing is better. Other top clauses that you might see in there: choice of law and choice of forum. So this is basically setting forth at the beginning, if litigation were to occur, what law would occur. So you could say it's Ohio. You could say Florida. You put that in the contract. And then also, where would the litigation be held? That's something that you need to know. Now, the place, the law that applies does not necessarily have to be the same as the forum. So sometimes strategic decisions are made about what law protects the rights of generally the employer or the more dominant party, and they pick that, and then the forum is what's convenient for them. So you want to check that out, see what's required there, and understand where litigation would occur if this provision is in there. Another clause that to think about is a severability clause. And basically what this clause does is if there's any provision in the contract that's held to be illegal, instead of the entire contract being nullified or terminated, what we will do is pull out or sever that one bad clause and allow the agreement to continue to go forward. Okay, so now we're at the end. I have two questions, and then we will move to the exercise. So the first question is, what are the key steps that a healthcare provider should take prior to signing an employment agreement? Based upon our conversation, what are the key steps that a healthcare provider should take prior to signing an employment agreement. Okay, so those are the key steps. So first of all, good. You want to make sure, again, that you read the document. From now on, after this particular session, you're going to read things before you sign them, especially very important documents like employment agreements. And you also should have it reviewed by a lawyer, but remember the lawyer should be licensed in the jurisdiction where it's going to be enforced, right? Because that person will know the unique state rules that govern contracts in that state. So those are definitely key things that you want to do. The next question. What are the key topics that a healthcare provider should consider in negotiating and reviewing an employment agreement? What are the key topics that a healthcare provider should consider in negotiating and reviewing an employment agreement? All right, so these are very good answers. And basically, you should look at the topics on the handout that I just gave you, that we gave you at the beginning of the session. So now what we want to do is I want you to participate and review this exercise. It's called the Eagle Eye Review. You should now see that on the screen, and you should see it available for you to upload. And we're going to take about 10 minutes for you to read this document. And what you're to do is you read it as if this was an employment agreement that you received, and identify the questions you would want to ask an attorney if this was an agreement that you actually received. The key thing that I do want to let you know that this is not an entire agreement. It is excerpts, okay? So it's not a full agreement. It's excerpts. But so take the time, take about 10 minutes to read this exercise, and then we'll come back and we'll talk about what are some of the things that you would want to have answered, and if there are any other questions that people have, we'll take those at that time. Okay, so you all should be wrapping this up. I'll give you about 2 minutes, and then we'll come back, and you all should type in some of the questions that you think should be asked to an attorney if this was an agreement that you actually received. Okay, so let's come back together and write down what are the questions that you would ask an attorney if this was an agreement that you actually received. Okay, so I'm looking at some of the responses. The two primary things that are concerning is the salary in the agreement, as noted by some of the participants, is not what was talked about during the negotiations. And this is particularly problematic because this sample excerpted contract has an entire agreement clause in it. So that's why it's very important that you read very carefully the document that you receive and make sure it reflects what it is that you talked about during the negotiation process. Because if you sign this, then you would be stuck with the lower salary. And the second problematic provision is the one also noted by some of the participants, and that's the fact that the restrictive covenant is for 5 years. That is extremely broad and very unlikely that a court would find 5 years reasonable given the highly mobile society that we live in today. Some other participants talked about missing provisions, and of course you want to consider all of the topics that we talked about if you're negotiating an agreement, but because this was an excerpt, I wanted to do something relatively quickly, I didn't include everything. So the key thing is that you use the one-page handout that I gave you at the beginning to trigger topics that you should be thinking about as it relates to your employment agreement. I do have a book that I wanted to recommend that's reflected on this slide, it's not unique to healthcare providers. It's about negotiating in the employment context generally. And it has some good tips in there. They have it available in softback. I would buy it on Amazon.com and get, whatever version you're used to. I like used but like new, but if you can have something marked up, you can get it for a couple of dollars. And it's not a detailed, very thick book, but it is a very good negotiating tool and something that you could keep in your library and use and help you over the course of a career. So I would strongly suggest that you purchase this book. The final thing is that we want to take questions. So operator, if you could open the line for those people who are participating by phone, so that if people have questions by phone, I can take those. If you want to write some questions, then I can also take those. And then after we do the Q&A, the National Health Service Corps, they have a questionnaire that they would like for you to fill out, so stay on the line for that. But operator, if you could open up the phone line so that people could ask questions if they have any.
Thank you, Ms. Majette. I'd like to remind your listeners, in order to pose questions or comments, press star 1. Again, that's star 1 on your telephone keypad. We'll pause just a moment. All right, Ms. Majette, it seems you have no audio questions. You may continue.
Okay, so I also don't see any questions in the Q&A box. So I just do want to thank you all for participating in this webinar today. I hope that you enjoyed it and that you learned some valuable information that you could use in your professional career as you go forward. Again, stay on for the National Health Service Corps to have you complete a survey. Thank you.
Sorry, Gwen, you do have a couple questions coming in.
Oh, they're coming. Okay. Are they in the chat box or the Q&A? This one question? Okay. All right, so the one question that I have is what's moonlighting? So if you don't know what moonlighting is, probably not something that's done in your profession. But so mostly I'm familiar with it with physicians. So physicians will work for another employer after hours to gain additional money. Generally, when you're a moonlighter, you're not working for someone on a full-time basis. You're working for someone who has a need, and they fill it in with part-time people. So that's what moonlighting is. Okay. So the PowerPoint is not something that I provide based on the ethical rules that govern me as a lawyer. What you do have is the Negotiating Your Contract handout that has the key topics. If you were taking notes, those are things that you can take into consideration. And you have the sample contract, which has a couple of provisions in there. The more important document for you is the handout that laid out the topics. So one of the questions that I received is about general questions. If you have very general questions, you could email those to me, but I can't give you legal advice about the nuances of a specific contract. I would again suggest that you hire an attorney to answer very specific questions. The other thing is if you're a physician, I'm not familiar with whether actually, I have seen it. I know for physicians, the American Medical Association, on their website, they used to have a very general document that it might even be a sample employment contract. So that can be a resource. And I have seen, if you're a nurse, if you Google like employment contract for nurses, you also might find some documents. They won't have the level of detail that we talked about today, so you guys are fortunate, but it will give you some of the basic terms that you can have in an employment agreement. The AMA, they used to have an annotated document on their website, but it was unique to medical professionals. And I haven't looked for anything for other professionals outside of physicians and nurses. The other thing is that while you all are, I'm not sure if you qualified for this, but I would check into this. Many professional associations will have special membership for students. And I would try to make the argument as, well, you guys are still in school. Okay, so this does apply to you. So you're still in school. Check with your professional associations, and they have conferences where they talk about these topics. So I would try to go to one of those conferences and do it as a student, because your rates are so much cheaper than if trying to do that once you finish. So for everybody, I would find out what's the major association in my area nationally, and then I would also look regionally and locally to see if there's an association, and get fees to find out what their programs are, and go to those programs and do it now while you're a student, because you will get, the rate. Just to give you an example, like for lawyers, for a student to go to an American Health Lawyer Association meeting is $50. For an attorney, it's like, $500, $800. So it's a significant discount. So that is definitely something that I would suggest for all of you to check into. And Austin has put up for people that if you have questions that are unique about the National Health Service Corps, which I didn't go into that, and what are the contract obligations and what does the program expect to you, of course, then you should contact the National Health Service Corps. Okay, so please complete the survey, and thank you.
Ladies and gentlemen, this concludes today's call, and you may now disconnect.